let's get started. I'm going to share my screen so we can go through this new law case called the Kalway decision. That's what we're here about. Several of you, I'm sure, have already been part of other firms in discussions with this, whether in private or in a public format. It is a very interesting case, to say the least. I have, when these types of cases come out, all of us managing partners get on the phone and start talking to our friends at other firms to figure out what this means for us moving forward. So I would imagine that what you're going to hear me say, at least with regards to the summary of the case, is about the same as you've heard before. But I want to actually show you some of the statements in the actual case and then talk about what we do in this new landscape and address some of the concerns you might have and how we can continue to successfully represent communities when it comes to CC&Rs. So to take a step back, before I get into this, the disclaimer is I'm not giving legal advice because this is a group format. I can't give legal advice. So everything I'm talking about is just general information. Okay, with that, let me share my screen. And all of you should now see the actual case, Kalway v. Calabria Ranch. Now, let's talk procedurally about what happened here. First of all, before we dive into this, the facts, I think they're bad facts lead to bad law. I think you've probably heard that before from others, but let's talk about those facts. Under the background part here, you can see. Under background, so Calabria Ranch is a very small ranch of 5 total lots. And Mr. Kalway owned lot number 2, which was about 23 acres, all right? And his lot 2, was the largest of all these 5 lots. Because it was so large, he had 6 votes. So basically, this community had these provisions here that said this, and you probably have seen these before in the past. You've seen this language here. It's a general amendment provision. It allows you to amend the CC&Rs at the very end. It always tells you, hey, what these CC&Rs can be amended by based on what the vote requirement's going to be. And we've been relying on these for decades to amend our CC&Rs. Okay? So the question now becomes, what happened? I think there's a lot of backstory here. I think that these owners, the other owners, and Mr. Kalway just did not get along. Water and oil kind of get along. I would imagine, I'm not saying that this happened, but I would imagine there might have been some yelling, screaming at each other because these facts tell me that that's kind of what happened. Basically, the rest of those owners, the other 4 lot owners, got together and decided that they were going to amend the CC&Rs. And when they looked at the CC&Rs, they saw that it only required simple majority vote. And they knew they had the votes because it was Kalway's 2 votes to the 4 votes for the other 5, for the 4 of the other 5 lots, right? So they knew they had the votes. So rather than notice Kalway of a proposed amendment and allow him to vote on it, they just did it. So in January, the other property owners, I highlighted this in paragraph number 4. So in January 2018, the other property owners enlisted, the Supreme Court says they're the other owners, amended the CC&Rs by majority vote without Kalway's consent or knowledge, which to me, that's already, if I'm a judge at the trial court level and I have somebody come to me that's challenging a CC&R amendment, if their attorney tells me that they weren't even told about the amendment, I'm not going to be happy about that. Look, you already had the votes. Why didn't you just include them in the process? And that was one of the things they argued. So bad facts coming in. I think that probably already set the tone of where we're going to go with this. So fast forward. basically it goes to the Court of Appeals. In the Court of Appeals, Kalway argues in his appeal that all the amendments that were done by this group in his community were invalid because why? They should have it required unanimous consent. And he lost in the Court of Appeals. The Court of Appeals disagreed. So not looking very good for Kalway yet. But the Supreme Court then picks up his argument, decides to grant review, and now we're at the Arizona Supreme Court level. This decision we're going over is the actual rulings by the Supreme Court of Arizona. Some of you have asked, okay, can it go higher than this court? And the answer to that is no, not on a state law issue. This is as high as it goes for state law issues. So why did the Court of Appeals disagree on that? Because this is what they said, highlighted. Applying Dreamland, the court concluded Kalway acquired his lot with notice that the CC&Rs could be amended by majority vote, and that the general purpose statement in the original declaration was sufficient to provide notice of the amendments. And oh, by the way, part of the argument by the association, other owners, was, hey, listen, not only do the CC&Rs say that we can do simple majority vote, but the law says it, the statute. And specifically on paragraph 10 here, Arizona, and the Supreme Court recognized this, Arizona law permits the amendment of CC&Rs by a majority vote if such voting scheme is specified in the original declaration, which it is, right? And that's this statute here, ARS 33-1817, subsection A. So he loses on appeal, and he submits it now to the Supreme Court. Now we get to the Supreme Court under paragraph 10. Let's talk about, this is the Supreme Court analyzing what happened up to this point, but now let's get to what actually happened in the Supreme Court. So first of all, the Supreme Court has to address in its analysis the statute that's out there. Okay, so they recognize that the statute, the legislature said that, hey, if your declaration, i.e. CC&Rs, allows you to amend with simple majority, you can. But here's where it gets a little interesting, not a little, a lot. This is where we start going down the rabbit hole. But ARS 33-1817 does not displace the common law, which prohibits some amendments even if passed by a majority vote. And in red, the original declaration must give sufficient notice of the possibility of a future amendment. That is, amendments must be reasonable and foreseeable. This is the new standard under common law that the Supreme Court has set. This provision in red. So even if the statute allows you to do simple amendments amendments by simple majority vote, even if your CC&Rs have the simple majority vote, or 67%, like a lot of them do, or 75%, the bottom line is that while you can defer to the statute, that's not the end all say all. You have to defer to common law as well, which the Supreme Court is essentially trumping the legislature and saying, under common law, any amendment must be reasonable and foreseeable. So what does that mean for us? What it means is, this is what the court says. If an amendment's invalid, we blue pencil the amended CC&Rs, striking severable provisions. What does it mean to blue pencil? Blue penciling means that the trial court has to get out a pencil, essentially, a blue pencil. I'd say blue pen, because I don't know of any blue pencils, but a blue pen, which is kind of indicative of original ink, right? When you sign a contract, if it's blue, you know that's the original, if it's the original. And then they blue pencil out and they strike the provisions or the sentences or the words that the court feels are unreasonable and unforeseeable. So notwithstanding a general amendment provision at the end of the CC&Rs, if you're going to amend any provision in the CC&Rs now, a homeowner can challenge that amendment by arguing that the amendment was not, that the general provision at the end didn't make it reasonable and foreseeable that the specific provision could be amended. So let me give you an example. I'm going to go back to, that's my statute search. Let me pull up the actual, oh, sorry. Give me a second here. Hopefully you're not getting too dizzy there. I stopped sharing my screen for a second so I can pull up my summary of the provisions that are actually at issue. Okay, I'm going to reshare the screen now, and you'll be able to see what the court did here. So this is what they did. This is the blue pencil rule. They looked at the amendment that was passed, and then the court strike out the part they didn't think was reasonable and foreseeable. So they struck out this part. In the event of any potential future subdivision of the lots, the allocation of votes shall remain the same with any additional lots. With any additional lots or parcels having no vote under this declaration. Another one, sorry folks. Christy, please make sure that everyone's muted as they come in. Another one, the chicken one. This is what, to me, is pretty scary. On paragraph 34, no owner or occupant shall keep more than 6 livestock animal units per 3.3 acres on their lot. And then they struck out this on their what? So this is the original part. And they struck lot and livestock shall be limited to chickens, horses, and cattle only. So the Supreme Court essentially said, we're going to blue pencil out, we're going to strike out any amendment that attempts to modify what type of livestock can be on a property. The reasoning for it goes back to this. I'm going to go back to some of the reasoning here that's more highlighted. They incorporated a case called the Dreamland case. And in the Dreamland case, they said that an HOA can't create new affirmative obligations where the original declaration doesn't give you enough notice about creating these new affirmative obligations. Put differently, summarizing what this actually means, taking away the legalese. What it essentially means is, if you're going to place an affirmative obligation on what somebody can do with their lot, i.e., if you're going to restrict or modify what somebody can do on their lot or their unit, then I think you're in the Kalway territory of this reasonableness and foreseeableness and the potential for it being stricken. So if an amendment doesn't really restrict what I can do on my property, then I don't think it's going to be a problem to rely on the general amendment provision. So an example might be incorporating capital improvement fees upon sale of a unit, where the buyer or the seller have to put up money in closing, transfer fees, reserve contribution fees. These are all buzzwords that several of you are familiar with. At closing, those are monies due to the association, and they go to the association. That doesn't have anything to do with the use of a lot. So I think you're outside, you're going to be safe relying on general amendment language. Having said that, Kalway opens the door to the argument. And until we have case law, I suppose a court could say even that's not safe. But based on what they did strike through, I think that's safe. And frankly, I've talked with several other managing partners. We kind of all agree on that we think that's going to be safe, because it doesn't impact what you're able to do on your property. Here's another provision, paragraph 17. The restriction itself does not have to necessarily give notice of the particular details of a future amendment. That would rarely happen. So the court's saying, okay, we know that most provisions aren't going to say in the provision, oh, and by the way, this provision can be amended, but pursuant to the general amendment language down below. That just doesn't happen. We've never really seen that. So they recognize that. But they do say instead, it must give notice that a restrictive or affirmative covenant exists, and the covenant can be amended to refine it, correct an error, fill in a gap, or change it in a particular way. So what does that mean? How do we know what that means? There's a lot of dust that was thrown in the air with this, because this the main holding that we talked about in red a couple minutes ago about reasonable and foreseeable, that is not an objective standard. That is subjective. So anytime a CC&R challenge is made in the court, it's highly unlikely you're going to be able to now resolve this in a motion on an issue of law because of the subjective standards. You have to go to trial to figure out and present evidence why it's reasonable and foreseeable that it could be amended. And we're going to have to now go to court and get additional guidance, in my opinion, and in many others' opinions, on what it means to refine, correct an error, fill in a gap. The Supreme Court, admittedly, as part of its analysis below, tells us why they blue pencil and strike out certain provisions of those amendments in this community, but they open the door to additional questions. So lastly, and then I'm going to talk about specific examples for us and what this means for us and how we can navigate today's climate. This is the last statement about this case I'm going to make. Future amendments cannot be entirely new and different in character, untethered to the original covenant. So what does that mean? We don't know. I would think it meant that if you have an original prohibition in your original declaration about livestock, that you could amend that to kind of define what livestock actually means. But the Supreme Court here struck any reference to amending actual livestock requirements. So we just don't know. We do not know. And what this ends up meaning is every trial judge now has to pick up their blue pencil, strike what they feel is unreasonable and unforeseeable, and keep what is reasonable and foreseeable. So the next question is, okay, let's talk about a few of these amendments that you're all familiar with and that we're doing right now. One amendment that we have on the books. When this case came out, we had dozens of these amendments at our office, as well as other firms. CC&R amendment to prohibit short-term rentals. Now we know that both the Condominium Act and the Planned Communities Act says that the declaration, i.e. the CC&Rs, can contain time restrictions, quote unquote, time restrictions in the declaration. So the statute gives us the expressive right in the declaration to amend it, if it doesn't already have it, to amend it in, subject to some arguments that, in Condo Act specifically, some argue that you need unanimous consent. I don't think you do. That's already been resolved by the courts with Planned Community Act. It may be resolved in one of our insurance defense cases soon, because we've got an attorney that represents a homeowner suing, saying requires unanimous consent. But now, in the wake of Kalway, the question is, does a short-term rental require unanimous consent? Is it reasonable and foreseeable that that leasing provision could be amended by the general amendment provision to incorporate a time restriction? My argument is yes, because I've seen some of the emails out there about the coalition of homeowners that said, oh, now you need unanimous consent specifically for short-term rentals. When the statute, however, says you can specifically have time restrictions in the declaration, I think that's a good argument that you can amend pursuant to the general amendment provision. But here's the huge caveat. The huge caveat here is, I don't know if I'm right. The best we can do right now is 50-50 in the wake of Kalway. So the advice that I and everyone else is giving right now is, if you want to amend your CC&Rs to include a short-term rental provision, it's 50-50 if it's challenged. And here's one of the reasons why. When the Supreme Court essentially trumped, pulled out its ace card in this poker match and said, we don't care what the legislature said. That's a start, but you have to apply common law. So when the Condo Act says, or when the Planned Community Act says that you can amend a provision and for time restrictions, time rental restrictions, and the court's going to say now, well, okay, but we still have to apply common law. So we don't care essentially what the Condo and the Planned Communities Act say about amending, or and frankly, we don't care what the general rental amendment provision or the general amendment provision at the end of your CC&R say. What we really have to care about is whether imposing a time restriction, like not less than 30 days into CC&Rs, is reasonable and foreseeable. And then it was reasonable and foreseeable that could be imposed when the owner purchased their property by pursuant to the general amendment provision. It's 50-50 right now. So for those communities that want to just continue forward, business as usual, impose their restriction until a judge tells them they can't, and they're okay with that risk, fine. I do think there are good faith arguments to be made that you can continue forward. But the big caveat, again, is it is 50-50 whether you're successful in that. If I had a personal, like a crystal ball, and I could predict what's going to happen in the wake of Kalway for the next 5 to 10 years, I think I'm right on this. I think the court is going to clarify and distinguish this ruling. Why? Two main reasons. Number one of the principal reasons why the Supreme Court gets involved is to settle the law, not to create more questions, but to settle the law. Number two is to reduce the amount of litigation over issues of law. Did this case settle the law? Yes or no? Arguably, the answer is no, with a big exclam. What it did, and arguably, it's going to create a massive influx in litigation and a massive increased workload on trial judges, because up to this point, trial judges like to have laissez-faire and just say, hey, look, I'm not going to interfere with what the party's contract says. If the CC&Rs and the statute allows you to amend, you can amend, period. But now they have to take out their pencil and start blue lining all the parts and striking all the parts that are unreasonable and unforeseeable. So that's going to create a lot of work. That creates the exact opposite of what our Supreme Court is here for. And why did that happen? I can only speculate. I follow like other people. We followed this case through the mix. When we saw the Court of Appeals decision, we're like, oh, okay, cool. We did not see the Supreme Court coming on this. It was shocking to all of us. So again, because those two primary purposes, I think, are defeated, because I think that the court's going to have to do something, because here's an absurd argument I could make now based on this decision. I don't think any court would ever accept it, but it's an argument I can make now in good faith. If I am either an association or a homeowner, I can now argue that the statutes just don't apply, that the legislature exceeds its authority by imposing legislation on the party's right to contract. Why? Let's share the screen again. Let's go back to this statement here under paragraph 10. The statute does not displace the common law. And there's a common law case out there that says that the private party's right to contract shall not be infringed by the legislature. So if I want to make the argument now, again, an absurd argument, but nevertheless, a good faith argument, that this provision or that provision, or perhaps even the Condo Act, or perhaps even the Planned Communities Act doesn't apply because it doesn't displace the common law. And there's a common law case that says that parties should be able to contract without interference with the court or without the legislature. Is that going to be successful? Probably not. Do I want to bring that because I want to help advance the court giving us additional case law to clarify what's going on here? Yeah, I would. Right now, I would love to see us go back to the legislature to try to correct this case. But here's the problem with going to the legislature. And I'm not saying a problem is in a big problem. I think that there's a lot of chatter going on to go to the legislature next session to present a bill that hopefully will be passed to get us back on track with general amendment provisions. But if that law is passed, if that statute is passed, does it automatically trump what Kalway says? Maybe, maybe not. 50-50 again. Why? Because we have this statement right here. The court saying, we don't care essentially what the statute says. It's a good start, but the ultimate stop is what the common law says. Common law being what the court created law says. So they could pull out any number of things and say, well, yeah, you tried to amend this, but to get rid of this decision, but it's null and void because we don't care if there's a conflict between the statute and what we just created, we have to defer to the common law, which is a power struggle, but ultimately it still ends up with a very interesting analysis of what's going to happen in the future. I still think we need to go to the legislature. I still think we need to legislate in things as fast as possible to try to get us back on track, to avoid all the ripple effect. But again, the common law applies, and it's going to result, as you can see and feel, lots of litigation over this, whether the statutes apply, whether this provision is right, whether this provision is wrong. I had a hearing with a very well-known homeowner attorney that represents homeowner attorneys a day after this came out. And naturally, that's going to be the topic of conversation as we're walking to our cars. And his point was, dude, I've already emailed out to many of my homeowner clients, potential clients, a statement that, hey, we can challenge any CC&R amendment. So, okay, great. You can see a spike in litigation. Part of the Attorney Employment Act, I guess. Now, enough with all the doomsday. Let me talk to you about a few things that, well, let me look at some of these chats and see if there's any additional questions I can answer real quick before I get into our next point. Yeah, Paige, I agree with you. They should not have applied Dreamland, but they did. Yeah. Oh, by the way, a good point here is, and I was going to mention this and I forgot to, the case was not litigated by any HOA law firms that you know. It was litigated by, it was a Tucson case essentially. And one of the Kalway's attorneys I've seen dabble in the HOA world when it comes to some arguments, but I've never seen the other guy. And that's not to say he hasn't ran HOA cases before, but if HOA attorneys that were involved, it's my personal opinion that they could have done a better job explaining how this impacts the HOA world. For all the reasons we just mentioned, and all the worries that you have, all the extra litigations this is going to create. So, perfect. Those are the comments that I'm going to get into now. Now let's talk about, okay, since we are on this short-term rental topic, I know that's a lot of people's concerns. How do you essentially stop short-term rentals without amending your CC&Rs? It's a good question. Well, ARS 33-1260.01 for condos and ARS 33-1806.01 for planned communities say a couple of things. First, they say that an association can adopt rules to demand tenant registration. The second thing they say is that landlords shall abate criminal activity on the land they control. Okay, great. One of our communities, well, lots of communities adopt these tenant registration provisions. So anytime anyone ever rents to a tenant, they technically have to disclose that information. If they don't disclose that information, you can charge them $25, which the statute sets it at $25, and then a $15 late fee, I believe. That certainly does not punish somebody. So 20, 30, 40, anything less than $50 when you're dealing with a pretty big 2-3 day contract for, who knows, $500,000, whatever it's going to be, doesn't really help to incentivize that guy or gal from stopping the short-term rentals. But what we did do and can do is you can seek an injunction against the individual to comply with the tenant registration, to continue to submit and require them to submit all this information every time a lease is entered. That is something you can still do, basing that analysis on the rules. And frankly, if I'm a landlord doing short-term rentals, I would hate to have to tell every one of my short-term tenants, oh, I got to disclose your information, your vehicle information, when this lease starts, when it ends. I got to disclose your contact information to the HOA. And because the statute's clear on this, you can do that. And we've done that successfully. Now, is that going to get them to stop? Maybe, maybe not. But it makes it more difficult to rent. And frankly, if I'm the landlord, I'm looking at it from a pure business perspective and from a customer satisfaction perspective, I don't want to get negative reviews about having to submit these guys' information to the HOA, because that can happen. And it does happen, by the way. People do submit negative reviews about their landlord submitting their information to the HOA. They want to keep their information private. If I go to a short-term Airbnb for a weekend in Scottsdale, I don't do this, by the way, for those CC&Rs, but let's say Durango, because I love Durango. I love that area, Southwest Colorado. If I go to an Airbnb with the kiddos for Christmas break to go skiing with the family, do I want that condominium disclosing my personal information to the board? No, I don't. So I'm not going to be happy about that, especially if the board, contacts me about my vehicle being parked in violation of the CC&Rs. So that is one tool you can use, and I think arguably can still use in the wake of Kalway for short-term rentals. And that's important to keep in mind. Okay. It's now 12:37. I usually promise that I keep this to about 30 to 45 minutes. I'm going to look for any questions. Are there any questions about this with any other type of CC&R amendment besides short-term rentals? There's a question about simple nuisance complaints by owners for the constant traffic. And that's a very good point. Here is a general nuisance provision in most of your CC&Rs that say that essentially you can't interfere with the quiet enjoyment of other members. So can it work? Yes. Can it not work? Yes. Ultimately, I don't like to litigate over just the nuisance provision because it takes a lot of work. Again, nuisance is not an objective standard, it's subjective. So anytime you hear the word subjective, you got to think that I'm on the clock for a heck of a lot longer than I would be if under an objective standard. So now I need to prove up that it's a nuisance under this standard. I need to know how much traffic's come in. I need to know how loud it was. I need to have witnesses telling me on the surrounding neighbors that this was loud, party, blah, 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 blah. And all of that takes time, energy, and effort. Another thing, because we're still on short-term rentals, and just kick it off to the respective city for potential enforcement. There are still things that the city can do, and that's good. Another one, what do I think it will take to overturn this decision? Like I said, we don't overturn anything when it comes to Supreme Court. The only one that can overturn the Supreme Court is the Supreme Court. And that takes time, energy, and effort. We can try to overturn this by legislation, but whether that ends up working is a question mark because of this paragraph 10, where they say, but. So I think that I want to start with legislation. I think that's going to springboard this into a faster approach, because what happens? Let's say the legislature adopts a statute next session to help right the ship. Well, it's going to probably be challenged pretty quickly by the likes of homeowners attorneys. And that will then hopefully allow us, HOA attorneys under the insurance defense time, to make the arguments that we're presenting today about all of the problems this can create for us. So we can then get that to the Court of Appeals as fast as possible on why this Kalway decision needs to be distinguished or modified, and then kick it up to the Supreme Court. And hopefully the Supreme Court, in our petition for review, or our response to a petition for review, if we won the Court of Appeals case, can articulate why the Kalway decision needs to be distinguished, modified, or overturned. So the Supreme Court hopefully will see what's going on here. But again, that takes time. For those of you that are involved in litigation from beginning to end, getting to the Supreme Court, I mean, you saw it in the facts. In January 2018 is when that amendment was done. So that means the lawsuit was filed in early 2018. And just a couple of weeks ago is when we got this ruling in 2022. So 4 years, 4 years. For those of you that were managing when my Turtle Rock 3 case came out, that took, when the Court of Appeals issued that horrible ruling, and then we got the Supreme Court to toss that decision by depublication. Well, that took from beginning to end 3.5 years, I think is what it was, 3.5, 4 years. So we're living under this regime for 4 years if nothing is done. Frankly, though, if the legislature does something about it next session, I am going to advise my clients, go ahead and move forward with the general amendment provision pursuant to the statute. But just know, there's the caveat, you're still in risk territory. There's no attorney in this space is going to tell you you're safe on a CC&R amendment that restricts what somebody can do with their property. I think most of us, like I said at the beginning, are going to tell you amendments to like strike declarant out and post turnover, or amend in transfer fees, or do other things that don't restrict what people can actually do with their property. Those are going to, most of us are going to tell you, we think that's safe. But the ones that tell you what you can and can't do, or modify what you can and can't do with your property, you shouldn't be hearing that you're completely safe, even if the legislature adopts that change. Why? Because of this big, in fact, I'm going to make this red, because of this big red but. Okay, I'm going to finish this out by talking a little bit more about common law. What does this mean? There's a couple of things. So going back to Dreamland. Dreamland here is common law now. It basically means exactly what the court summed up, because the court incorporated common law. They incorporated a case called Dreamland from a while back. They incorporated the Shamrock case. Interestingly enough, when I first started practicing law at a firm called Jackson White, they represented Shamrock because they represented homeowners at the time. And I was involved in this Shamrock case way back when with the managing partner at that firm. It was his case, and it went on for years and years. Between you and me, I thought that the court wouldn't do what it did. I thought that, but Jackson White, or I should say Shamrock, won. Anyways, that was an interesting point. But the bottom line here is this part here, which I'm going to change again. The common law says simply reasonable and foreseeable. What is reasonable? We have another common law case called Tierra Rancho v. Kitchikov, which talks about factors to consider in what's reasonable and foreseeable, like impact on the property, the visibility of that decision, or the reasonableness of what the board is doing. And I think you can apply that. While those dealt with duties of a board, I think you can apply some of those factors here. But the rest of this case, when they talk about why they're striking certain provisions, it doesn't get much better than this. They just kind of tell us why they think it's reasonable and foreseeable. But if I got into the specifics of that, it takes us down a rabbit hole where you could argue both ways on any provision. So no, the reason why a lot of us aren't able to give you very specific objective guidelines on what reasonable and foreseeable is because now it's the scenario of you cut one head off, two heads grow back on every point here. So now there's arguments that both sides can make. That's why, again, I hope we can get to the Court of Appeals and argue this is reasonable and foreseeable, that this amendment can take place. But this is also supportable by the new law the legislature just passed. But also, if you don't take this approach, even under the common law, you're supposed to not create unnecessary litigation. You're supposed to clarify the law. And this decision did the exact opposite. And here's why. There's been 150 cases filed since then. No community is able to amend their CC&Rs without this concern. There's been a complete standstill on what homeowners can do. Because another thing here is, what I find very hypocritical is these homeowner rights groups say, we've won. But a CC&R amendment is a homeowner, it's a homeowner movement. It's not a board movement. It's not the board that does that. It's the homeowners. And it's not just a very small percentage of the homeowners. It's like the majority of the homeowners have to get this done, if not a super majority. So it is the homeowners' express will to amend the CC&Rs. It's not the board's will. And I find it extremely hypocritical for the homeowners groups to say we've won, because it's like shooting themselves in the foot. You haven't won. You've hurt yourself, homeowners. This is stupid. And I think that's what the Supreme Court needs to understand, because in light of this decision, it feels like they were trying to make it better for the homeowners, turning back to favor of free use of property for the homeowners. But one perspective is it made it harder for the homeowners. It made it less favorable for the homeowners. So with that, I'm going to end. If you ever have any questions about how you can apply and operate in today's world with amendments, like I mentioned with that short-term rental, that is something we can still do relying on rules. And then enforcing the actual rule provisions to resolve the issue before we can get back to amending CC&Rs if you're concerned about the 50-50 chance on most CC&R amendments. Anyways, thank you so much for your time. It's been an honor to have so many of you on today. And this has been recorded, by the way. It is CMCA approved for you if you have your CMCA, and our office will be sending you your respective documentation for the course in the near future. Caveat here, I think as of today, let me amend my statement. I don't think it's actually approved as of today, but I know it's been submitted for approval, and I don't think it's going to be a problem for the approval, because we always get those approvals anyways. So in any event, thanks again. Have a wonderful day, and we'll talk to you later. Bye-bye.